Amy, if you could please launch the PowerPoint that we have prepared for today. We're going to hear from a lot of great speakers. I will keep my portion short and sweet. But first, I want to introduce the report that you're about to hear about. It is a supplement to our, and if we could go back to the first slide, please. It is a supplement to our Housing Not Handcuffs 2019 report, which is the latest in a survey of city and county policies that criminally or civilly punish life-sustaining activities of unhoused people. Since 2006, the Law Center has tracked 187 cities and counties across the United States and has looked at the unfortunate rise of policies that make it impossible to legally survive in public space, even when there are no housing or indoor alternatives available to people who must perform those activities in order to survive. As a supplement to that research, we have produced the first ever state research of policies that punish the life-sustaining activities of unhoused people under state statutes. And you'll hear about that, including from the primary author of the report, Rajan Ball, who I know a lot of you know. Next slide, please. We have some great speakers today. You're going to hear from Rajan Ball, who, as I mentioned, is the lead author of the report. You'll hear from Representative Eric Morrison from the state of Delaware, Representative Campos, who is from the state of Oregon, and our own Joe Abraham, pro bono counsel in Texas, who is fantastic. And these panelists will be your primary speakers today. I'm going to move very quickly to Rajan after a couple of housekeeping items. First, you can enter in your questions in the chat. We do encourage you to ask questions. We should have time at the end for our great panelists to answer those questions. So feel free to enter those right in the chat. And to the extent that we can, we'll answer them in real time. This is being recorded. You can find it on our website. So be on the lookout for that later on. Next slide, please. Here's a quick overview of the agenda. You'll hear from speakers across the country, and we will get right to it with the introduction of the featured speaker for today, the primary author of our report, Rajan Ball, who will describe the findings of the first ever state criminalization report. Rajan, it's on.
Thank you so much, Tristia. Great to be here with you all. Hello, as Tristia stated, my name is Rajan Ball. I used to be the H&H campaign manager at the National Homelessness Law Center a little bit ago, so I've likely worked with many of you. So I'm very happy to be here and happy to be speaking about something that I spent a lot of time working on while I was at the Law Center. As Tristia indicated, what the National Homelessness Law, The National Homelessness Law Center has spent a very substantial amount of time and effort tracking the criminalization of homelessness across the country, but has largely done so at a local level outside of federal initiatives and national legislation that's been proposed or discussed, especially recently. But in terms of systematic tracking, was largely doing so at the local level through the Housing Not Handcuffs criminalization reports. What we realized at the time, especially recently, as more states had started to introduce state-level legislation in the last couple of years regarding practices that involve homelessness and respond to homelessness and that criminalize or restrict homelessness or behaviors related to homelessness, that we didn't actually have a database or a set of data available regarding the state-level equivalent to the local reports that we've been putting together and tracking. So that's a gap that we noticed in our reporting and that we addressed through this report. So the goal of the report was to track and to supplement the criminalization of homelessness through the Housing Not Handcuffs reports that we've had, but at the state level. There has been, at the state level, a recorded increase in the criminalization, or excuse me, at the local level, a reported increase at the criminalization of homelessness across the country, pretty much across the board throughout since the Law Center has been reporting it, which isn't great Communities are generally looking at homelessness or addressing homelessness as a local issue at the local level with respect to what their needs are. But the reason it matters that we look at the laws at the state level is because those communities are constrained by laws that are introduced at the state and federal level with respect to how they respond to homelessness at the community. For example, and we will hear from him later, Joe Abraham will be speaking about a statute that was introduced and unfortunately passed in Texas in this last year that really limits how communities in Texas are able to respond to homelessness at the community level within their own statutes because of what's happening at the state level. So we have to acknowledge and understand what the state level statutes are so that they can inform local responses. So what we did was a systematic review of state level ordinances that impact the criminalization of homelessness. We tracked similar types of criminalization measures as we did in the Housing Not Handcuffs campaign reports. These include bans that restrict sleeping, camping, lying and sitting down, vehicle habitation restrictions, laws regarding loitering, laws regarding vagrancy, and laws regarding panhandling. Communities across the country typically have restricted behaviors that people experiencing homelessness might try to do, for example, sleep outside, and we wanted to see if they were doing similar things at the state level. What we found, unfortunately, was that state level ordinances were far, far, far more common than we had thought, far more common than we had anticipated, especially considering the dearth of a database available for state level criminalization. We found that 48 states have at least one law at the state level that restricts or criminalizes homelessness. That's pretty much all of them. Now, it's important to acknowledge that at the state level, a statute being there or not being there does not speak to how it's enforced. We don't know whether the specific states that have these statutes are actually enforcing some of these laws, but we do know that generally, as I said before, at the state level, a state statute would overrule conflicts at the local level, even if we don't know if they are being enforced or if people are being criminalized as a result of the statute. So what you'll see when you look into the report a little bit later, and we're going to keep it at this page for now because this has the best overview of the criminalization measures in the report, the page that's open now. But later on in the report, there's an appendix that will break down the state statutes, and which you can all see in a little bit. But knowing what we do in front of us, I need to emphasize that our report is likely under-inclusive. And by that, I mean, while we looked pretty diligently for state statutes and instances of criminalization at the state level, states are describing and categorizing these statutes in different ways, putting them in different places in their state codes, and using different language to describe them, such that what we see here probably doesn't even actually cover it. There's likely something missing. Not that this is not me describing the accuracy of the report as suspect, but just that even if we have 48 states already, there's probably a couple more things out there too. So I wanted to talk about some specific state level laws that were worth noting. All of them are worth noting, but I wanted to talk about a couple specifically in the time that I had. With respect to camping bans, we found that 4 states up in front of you have laws that were statewide restrictions on camping in public: California, Florida, New Hampshire, and Texas. That's just one example. Mr. Abraham again will speak to the statewide camping ban in Texas and how broadly it prohibits camping, but I'll speak to Tennessee, where in Tennessee, it is currently a felony in Tennessee to erect or maintain a tent or furniture, to store personal belongings, cook or sleep on state property that's not designated for camping between 10 p.m. and 7 a.m. And that impacts what the local cities in Tennessee or what other communities in Tennessee, how they want to respond to camping, because there's a state level felony for doing so on public grounds. Another example is that in New Hampshire. In New Hampshire possesses an entire statewide sleeping ban with respect to public sleeping. As far as I can tell, it's the broadest in the country with respect to preventing someone from sleeping on state property. And as an example as to why some of these things are difficult to find, it wasn't just necessarily a criminal statute, but just that it was within their highway restrictions. It was within like a traffic restriction as a place to couch it. But in in New Hampshire, it stated that no person shall pitch a tent or place or erect any other camping device or sleep on the ground within the public right of way or on public property unless permission is received. So what we're seeing is that despite what cities in New Hampshire might be wanting to do, there's a statewide sleeping ban on public grounds. And these sorts of things are continuing across the country. There are vagrancy bans in Wisconsin and one other state that I forgot off the top of my head. I'm so sorry, but there's vagrancy bans even that prohibit in Wisconsin for someone with the physical ability to work who is without lawful means of support and does not seek employment, and or who derives part of his or her support from begging, and classifies them as a vagrant, guilty of a misdemeanor. And even still, states are prohibiting panhandling, restriction, lodging in vehicles, and other sorts of things that disproportionately impact people experiencing homelessness. So to conclude, there's much more detail in the report, including more accurate breakdowns of what I just described regarding which state is what kind of offense. But it's important to acknowledge that these offenses or these state level statutes are there, that these state level statutes are controlling in a lot of ways when communities are trying to address homelessness in their own ways, and that unfortunately these remnants of past historical problems for some parts still exist today and are still valid and are still impacting states across the country. So I'm really glad to have been a part of this project and to put this together of the National Homelessness Law Center, and I hope that it is a resource that is valuable for you all in your advocacy. So thank you for having me.
Thank you very much, Rajan. I wanted to emphasize a point that Rajan made about under-inclusiveness. So both the state report and our series of reports on city ordinances that criminalize homelessness, our Housing Not Handcuffs series, are under-inclusive in a couple of important ways. One, they look at narrow categories of prohibitions. So in the Housing Not Handcuffs report and the state report, we look at laws that explicitly ban activities that we all perform every day, like sleeping, sitting down, lying down, standing. But those are not the only types of restrictions that are enforced against unhoused people to prohibit those same activities. So, for example, we don't track trespass bans that can be used to prohibit people from occupying public space where they are engaged in that type of resting activity. So it's always important to keep in mind that even the large numbers, 48 states across the country, over 70% of cities across the country that prohibit these types of unavoidable and universal resting activities are under-inclusive of the penalties that unhoused people potentially face for living outside. There are numerous codes. They can be replaced, and that's why our advocacy has been limited. One of the main things that the Law Center does as in its effort to further its mission to prevent and end homelessness using the power of the law is to engage in impact litigation. We're often successful in our impact litigation, but that doesn't end the criminalization of homelessness. What we can do is enjoin enforcement of a particular policy or a particular practice, but that doesn't change the way that criminalization is growing in this country. And it's important for us to recognize why. Our laws reflect our prejudices, reflect our biases. And that's why we see, as unsheltered homelessness grows across the country, we see more laws that penalize people for being homeless. It is a growing problem, and it's not a colorblind problem. The data shows that Black and brown people experiencing homelessness are stopped, cited, and arrested more than white people experiencing homelessness. So there are layers of bias that are baked into the policies that are growing across the country in response to the crisis of homelessness that ultimately is solved with housing and not with police responses. Just a couple of statistics that I'll mention really quickly as we pull up a clip from the recent Last Week Tonight with John Oliver episode that focused on homelessness. When unhoused people are unnecessarily involved with the criminal legal system, they are over incarcerated. For example, in Portland, half of the arrests made in that city are of people experiencing homelessness. Portland is a city comprised of 3% of its general population are people experiencing homelessness. Gross disproportionality of how policing resources are used in the city of Portland. And it's not just Portland. In Los Angeles, a third of excessive force used by police against a suspect is used against a person experiencing homelessness. Los Angeles has the largest number of unsheltered homeless people in the country, but it certainly doesn't have so high a number that a third of excessive enforcement use is justified purely based on the numbers. We have to remember that this is a function of our own bigotry, and it's critical that we don't just use the law and traditional advocacy to combat the growing tide of criminalization. We need to be engaged in the messaging and narrative battle because that is where really the front lines of policymaking is done. We have to be clear that homelessness is not a function of bad choices. It's a function of a lack of choices. People live outside because they can't afford housing and because they don't have any alternative when they lose housing that is stable and adequate. And if we could pull up the John Oliver episode, I wanted to show this, one, because we are thrilled that the John Oliver producers reached out to us to help develop an episode on homelessness. He obviously has a huge platform. It's a great show. And we were able to contribute to what was really an excellent narrative and something that can be used in the messaging battle. And so we're going to show just a really brief clip beginning at around the 11-minute, 33-second mark. That will describe why criminalization of homelessness is unhelpful. But this episode also talks about the importance of messaging and the importance of all of us to check our own biases as we think about solutions to homelessness, like where to site adequate and affordable housing, where to site parking lots where people living in vehicles can safely park overnight or for longer periods of time. So we highly recommend that you check out this episode, and we'll show you a brief clip now.
Not just spikes and songs, more and more city ordinances have been put into place criminalising behaviours associated with being homeless. Over the course of 13 years, citywide bans on camping have increased by 92%, on sitting or lying by 78%, on loitering and panhandling by 103%, and on living in vehicles by 213%. So when you hear fear-mongering about rising crime among the homeless, it's worth asking yourself if those crimes were actually crimes or just someone sat down. Take Kenneth Schultz, a 71-year-old homeless man who told reporters, "Sometimes I just get exhausted and boom, sit down, that's it, you're trespassing." In the 9 years he's been homeless, he's been charged with trespassing 96 times and has spent 1 of every 3 nights in jail. And think about what that means. It means he spent 3 of the last 9 years behind bars. In what way is that man being helped? You cannot arrest someone out of homelessness in the same way that you can't sing someone out of bankruptcy. One thing doesn't remotely lead to the other, and you're just going to end up making things worse, even if you're singing this.
It's raining tacos, raining tacos.
No, turn it off. I am warning you, Ellen is sharpening her knives as we speak. She'll do it. It won't be the first time. And criminalising homelessness exposes already vulnerable populations to unnecessary interactions with the police. Unhoused people of colour are more likely to be cited, searched and have property taken than white people experiencing homelessness, and those with multiple marginal and those with multiple marginalised identities like LGBTQ+ people of colour are even more vulnerable to these laws. And if you're thinking, well, hold on, why don't homeless people just go to shelters? There can be a lot of problems with that. Some cities simply don't have enough beds for everyone. In Oakland, for example, in 2019, there were 457 beds available for more than 4,000 unhoused people, meaning they couldn't provide everyone with a bed, even if they Willy Wonkered the situation. And if I may, I'd actually like to pause at this point for just a...
So please do use the John Oliver show to the extent that it's helpful in your messaging. There are a lot of mediums that can be used to fight the narrative battle. And I just want to point out that the report that they cited to in that show is the report that is being supplemented and described for you today. So check out the reports as well. And with that, we're going to kick it over for, unfortunately, a little bit more on the bad news train to Joe Abraham, who will talk about the new Texas statewide camping ban. Before we turn it over to some of the amazing representatives who are working hard in their states to change the tide.
His grandparents.
Thank you, Tristia. Can you hear me? Okay,
Yep.
Great. Okay, so thanks again to Tristia for the invitation. My name is Joe Abraham. I'm a private practitioner in Austin, Texas. I've been working with the Law Center in a pro bono capacity going back to 2017, I believe. And what I'm here to talk about is contained in the new supplement at the bottom of page 9. In the 2021 legislative session, Texas proposed and passed a statewide camping ban, which became effective this past September 1st. And the bill criminalizes camping in a public place statewide. There are some additional wrinkles in the ban that I think make it a little bit different from what has been seen most before. There's a specific prohibition in the state law that states that a local entity may not adopt or enforce a policy that prohibits or discourages enforcement of a public camping ban. And that prohibition on local actors is enforced in the text of the bill with a mechanism that is not particularly well spelled out, but that at least states that any such local actor that discourages enforcement can risk loss of state funding and loss of state support. And not just limited to the area of policies directed to homelessness, but I think it's on its face broad enough to affect all state funding, which of course, I can't imagine there's any local municipality in the state that could actually afford to lose all state support. In terms of how we got here, we can't ascribe the new legislation to any one thing, but in 2019, the city of Austin, which is for reasons of basic political affiliation, a fairly frequent punching bag for the Texas governor and legislature, first dramatically scaled back its own local anti-camping ordinances. And then in the fall of 2019, after receiving some public outcry, contemplated essentially giving back many of those gains. Some of my former colleagues and I, my last law firm, assisted getting the Law Center. We tried to get Tristia and Eric basically in front of as many city council members and council staff as possible to present why criminalization was not the way, and that whatever could be done to preserve the gains the council had made earlier in 2019 should be preserved. And I think we like to think that some of that was successful. They did ultimately scale back somewhat, but we think it wasn't as bad as what was originally being contemplated before getting in front of the council. With that said, because of the significant publicity about the scaling back of the ordinances, there was definitely a significant increase in visibility of persons experiencing homelessness around the city of Austin. There were a lot more tents in public places, and it attracted a lot of public attention. And that, I think, basically got to be a political issue that gained in attention over the course of 2020. And then once the Texas legislature's every other year legislative session commenced in 2021, it meant there was this new state law that was being put forward. And so let's turn to that state law. The state law is still by and large referred to as HB 1925, the bill from which it was first introduced into the legislature. The key prohibition applying statewide is that a person may not reside temporarily in a place with shelter without consent. Now, there are many ways in which the state law is more restrictive than a lot of what's been seen in many local ordinances, as I understand. The type of shelter that the law prohibits includes anything other than clothing, which explicitly on its face includes sleeping bags, bedrolls, and blankets. In terms of conduct, for an example, sleeping alone can be an indicium of camping. So sleeping in a public place with a blanket without consent is now a prohibited activity under this state law. There's a very micromanagement element to the new law. For instance, it explicitly prohibits local actors from giving consent to use public parkland as an authorized camping location. So those are sort of the some of the highlights of what's bad about the law. There are a couple changes that were made that were accepted during the legislative session that made it slightly less bad than it could have been. There is now an explicit acknowledgement that cities and other local actors are allowed to pursue diversion policies and provision of services in lieu of citation and arrest. So it does not mandate citation and arrest, but still a city must not discourage enforcement. Where that line is, of course, is not very clear at all, and how it's going to work out in practice, I think, remains to be seen. So that's one, again, slight positive to the law. The other slight positive is that there is essentially a notice requirement. Assuming that there is no immediate danger, before a citation or arrest can take place, the enforcing officer must make a reasonable effort to advise of an alternative place at which the person who would otherwise be cited can lawfully camp. And also, and just to be clear, it is an and, must contact either political or responsible nonprofit actors regarding provision of services. That's the text of the law. It's still new. It's been in force 3 months only as of today. In terms of actual implementation, I think it's very much a remains to be seen situation. At present, including research done in preparation for this webinar, I am still not aware of any Texas municipality that has specifically instituted a policy in response to HB 1925. We have some reason to believe, for instance, just looking at Austin, where I live, that the city is certainly taking action with respect to some of the more publicly noticeable encampments of tents around town. So it is not being ignored, but neither is it being cited specifically. It's not being specifically referenced as a basis for enforcement, as a basis for citation. So all in all, the Law Center and various other Texas actors are watching very carefully to see what implementation is going to look like at the statewide level and at different local municipalities around the state. And if things come to a point where action is taken that looks like it could justify an impact litigation, such as Tristia mentioned, it's certainly an option that's under consideration. Beyond that, of course, I don't want to say anything more specific than I should, but that is that's sort of a high level overview of what we're looking at in Texas with HB 1925.
Thank you very much, Joe. We've heard a lot of what is wrong, and we also discussed how policy and litigation, policymaking litigation will not on their own change the world. Obviously, we need organizing, we need messaging, we need all of those systems working in concert. And we also need champions like the people you're going to hear from. Rep. Campos of the state of Oregon is our next presenter. She is the youngest person ever elected to the Oregon State Legislature. She is a person who has lived herself with housing instability, and she is a personal hero and absolutely the type of champion that we need in our state legislatures to combat the tide of criminalization. And it's my honor to introduce Rep. Campos.
Thank you so much for that introduction. I'm glad to be joining y'all this afternoon. So as mentioned, my name is Wednesday Campos, so she, her pronouns, state representative from Oregon. I was asked to talk a little bit about the work that we're doing in Oregon and what has brought myself to this work in the legislature and being an advocate for folks experiencing houselessness, for affordable housing, and all of these issues. I myself, the catalyst for me making the decision to run was actually because of the work that I was doing at the time when I made that decision. I worked as a case manager for a transitional housing program that helped families experiencing houselessness get into housing. And I had a day at work where I had one too many conversations with the families that I served about the lack of resources and solutions in the area. I started out the day with somebody who on a phone call, who by the end of the phone call knew that they were going to be sleeping outside because all of the shelters and organizations they had called had a wait list. I ended that day with a mom breaking down in tears in front of me, asking me how she was supposed to put a roof over her children's heads when she works 40 hours a week but only makes minimum wage. And she laid out what those numbers meant for her. It meant that every month, no matter how much budgeting or what have you she did, she came $300 short of covering the necessary expenses in covering bills. And so she left, and I sat at my desk feeling really angry and frustrated and thinking about all of these different stories that I have heard time and time again. And I thought to myself, what we need is change at a policy level. We need people that are on the front lines of the most pressing issues that we're facing, but we also need people in these positions who have direct lived experiences and diverse perspectives like those that I bring as somebody who grew up in a low-income household. From the age of 8 until I left for college, my family lived in a motel room because that's what we could afford. There were times in my life we had to go to the public library restroom to literally roll sheets of toilet paper to take home so that we could save $8 that week and put that towards bills. And so going into the legislature, I really wanted to be an advocate for voices from these communities, from folks who come from low-income backgrounds, from folks who are immigrants to this country. I myself am a daughter of immigrants, from folks who, who we're not hearing directly from because these buildings are inaccessible, because we don't have, thankfully, one of the benefits that we saw from this, from what we have lived through in the last couple of years, was a lot of legislatures moving towards making testimony more accessible through the virtual world, which has been able to bring in people that in the past haven't been able to, take a day off of work, for example, and go to the building and testify. All of that being said, I brought all of that with me into the building, that mindset. And in the work that I've done as a case manager previously, I really saw the injustices to folks experiencing houselessness, which is why I introduced the Right to Rest Act, House Bill 2367 in this last long session in Oregon, which died in committee, unfortunately. But it was a top priority for my office to address the ways that houseless individuals are discriminated against and persecuted simply by through the act of resting. So the object of the Right to Rest Act is simple. It decriminalizes the act of resting in public spaces in a non-obstructive manner. And my office had the opportunity to work with a pretty large coalition of housing advocates and such who've been working on this issue throughout the country for years. Hi, Paul. I saw that message come in. Paul with RAP, for example, was someone that we really had the opportunity to work with on this. We had the opportunity to work with Oregon ACLU, with mental health advocates. So, what we know and what we've heard here is that this criminalization houseless folks usually occurs, or we know it occurs at different levels of government and has long been used to abuse vulnerable community members, especially those who are houseless or from BIPOC communities. So it examines the variety of ways that people experiencing houselessness have been discriminated against in having the right to privacy violated while sleeping in tents or cars, being denied employment for their houseless status, having their property stripped from them during sweeps by private security when they have no other alternative, being perpetually denied reasonable or stable access to affordable housing, healthcare, educational resources due to a severe lack of accessibility. And so at the end of the day, the Right to Rest Act requires, it looks at all of these things, and what it does is requires that a public space that is open to the public is open to those experiencing houselessness who are members of our communities. That is, unless they are in violation of another law or causing an obstruction. What we have heard and what we are very much seeing in Oregon is that ordinances or city ordinances or state laws that criminalize folks do not reduce homelessness or houselessness. It does not do much to address this issue that so many talk about wanting to address. Instead, what it does is it increases incarceration rates. It increases the financial debt that folks carry. I have spoken with folks who call and are asking where they can, for example, where they can safely park their car overnight because they have nowhere else to go, and who have to go cities away from where their children go to school, from where they themselves go to work. And so we're creating all of these barriers for people who, I mean, there are so many stereotypes about those experiencing houselessness. And we know that there are so many reasons that folks fall into this situation. And so we know, and we heard it in the John Oliver clip, that there are folks that are out on the streets. And we know that some folks can't access shelter because there are places that don't have enough beds, but there are also other reasons we know that people do not enter shelter, be that maybe the shelter's hours aren't conducive to somebody's work schedule. Maybe the shelter doesn't allow pets, which for so many are part of the family. We also know that there are folks that have experienced severe trauma within shelters, or who have trauma that impacts their ability to really be able to enter shelter. And so So we're working on moving away from all of these stereotypes we have around these communities, and we're working as we look at this sort of legislation, which it may have died in committee this last session, but there is no way that we are done with working on this. My office will continue to make this a priority. We will continue to work with folks who are advocating on these issues, and we will continue to make sure that we are centering the voices of people who this directly impacts. One of the most interesting things that I found in having conversations about this legislation was that people would make comments about, well, if this is an issue that a city is seeing, well, then the city will let us know. We want to hear the opinions and perspectives of cities and those that we work with at those different government levels. Absolutely. But we need to look at the way in which we engage those who are currently out on the streets trying to survive. And I'm really proud to have, again, worked with folks who were able to bring in these folks, but we know that we are not doing enough to center these voices. And so that's what I have to say. Really appreciate the opportunity to be a part of this panel today. Thank you so much.
Thank you so much, Rep. Campos. That's wonderful. And I hope our audience is pleased to know that we have champions like Rep. Campos fighting for unhoused people on the West Coast. And we also have champions in other parts of the country as well. So we will transition now to a fabulous champion who is also working to decriminalize homelessness in his state on the East Coast, the state of Delaware. And with that, I will transfer it over to Representative Eric Morrison.
Hi, everyone, and thank you for having me today. It really is an honor and a pleasure. And I do have two very noisy birds, so if you hear something in the background, that's probably what it is. My name is Representative Eric Morrison. I am the state representative for the 27th District in Delaware, which is in the northern part of the state. And I am going to be introducing in January, when our session starts, legislation striking our panhandling and loitering codes in Delaware. When I first started looking at this, we were going to strike part of the panhandling code. Then we decided to strike all of the panhandling code. Then we also decided to strike both parts of the loitering code. We really just decided to go kind of whole hog on this. It's all tied in and it all goes hand in hand and it's all important. I actually started working on this last legislative session, which ended in July. And I was absolutely shocked because I send emails trying to get co-sponsors, and a lot of times people don't get back to you. So I'm very persistent. I'll text them. And I had a few representatives and senators call me. And these were Democrats. And a lot of reasons were given. What really bothered me, though, I have to say, to be frank, is that I think what it all boils down to in a lot of these cases is not wanting to be seen as supportive of people who are viewed by some people as nuisances. And no person is a nuisance. They are a person. A state senator, he basically said to me, I get calls about panhandlers, so I can't go in on this. And I'm like, she's thinking about the votes, and that really bothers me. And there were other reasons that we're working on. I won't go into all of them, but that was a little surprising to me. So we kind of said, we're going to put the brakes on now and get it together before next session. So we actually have the bill drafted. And actually something interesting is that last legislative session early on, a bill like this was drafted. And then it was stricken and suddenly disappeared. The sponsors never said anything. No one ever said anything. And I do suspect that that has to do with, political pressure and people being afraid at election time. So in our bill, we give a number of whereas statements. I really wanted to include those to educate people. So, in terms of why are we introducing this legislation? First of all, it's been decided in court cases, and thank you to Eric, who's on this call, for all of his help. We've had a great group of partners here in the state and outside the state. But, it's been decided in courts. This is a decided done deal when it comes to panhandling and loitering. It really kind of is. With all these cases where the panhandling and the loitering ordinances are being struck down. Also, it is a simple matter of criminalizing poverty and homelessness. And you don't end homelessness, as it said in that John Oliver segment, by criminalizing it. You're not helping people by throwing them in jail. You're not helping them by, as I heard from a former police officer who now serves in the House of Representatives, who opposes this legislation, that sometimes they would come before judges and the judge would say, oh, well, the fine's $100, but what do you have in your pocket? And they'd say $20, just give me the $20. So how does it help them to take their last $20 and send them back out? Another point that was made earlier, we have a severe lack of beds for homeless folks here in the state. It's absolutely atrocious. And while our homeless numbers have risen during the pandemic significantly, especially for families, our number of beds has gone down significantly. We're actually to the point where in one of our counties, we may soon have 0 beds, no beds. So where are these folks supposed to go? We also have no 24/7 shelters in Delaware, none anywhere. So where are these folks supposed to go when they can't be in a shelter? It's just, kind of a constant system of harassment. So what we've decided to do in terms of working on this bill is a two-pronged approach. For some legislators and other folks will be able to argue the side of stopping the criminalization of poverty and homelessness. For some others, we're really going to push the point of a lawsuit on these things is imminent. And we don't want Delaware taxpayers to have to foot the bill for a defense that is essentially doomed right from the start. So far, unfortunately, the Attorney General's office has said they oppose this if we're not going to replace it with anything. We don't know what that means, so we will be having a call with them. We also have, with our terrific group here, a lineup of online and in-person events regarding homelessness and the criminalization of poverty and homelessness here in Delaware. Those will be taking place in December. So we're really excited about those and trying to educate people and get the word out. Wrapped around this bill and also a couple of other bills some other legislators are working on, such as a homeless person Bill of Rights. To wrap up, I'll tell you one thing that really got me started on wanting to introduce this legislation. A while back, a year or so ago, I don't know, some of my family was down from upstate. They live downstate about an hour and a half away. That's how big we are in Delaware, an hour and a half each way. And we rode past a shopping center very close to my house. And my family member in the car said to me about someone who was, asking for money outside. Look at that guy. Look at that guy standing out there asking for money when he could go into any one of those stores and apply for a job. Well, I almost blew out of the car, but I said, let me use this as an educational moment. And I said to her, that's interesting. I said, you raise a valid point. I said, but let me ask you some things. I said, could he go in there the way he is dressed right now and apply for a job? She said, no. I said, do you think he has any better clothes than what he has on his back right now? She said, I guess not. I said, do you go into stores physically and apply anymore? Isn't it all done online? And she said, yeah, I guess it is all done online. I said, how does he have access to a computer? She said, oh, I guess he doesn't, but couldn't he use the library? I said, how's he going to get to a library? Where's the nearest library? It's miles away. Oh. I said also, how's he going to get a call back for an interview once he applies? She just kind of looked at me. I said, also, I said, even if he got the job, even if he could work, where can he shower? Where can he get clothes? Where can he be safe? Where can he have an address? Does he have a bank account? All these things. Even then, if he could get all that, where would he stay and what would he do until he saved up enough money, especially with what we're paying so many people today, to actually have a place, you know, to live. And it was really an educational moment. So I think we're going to be doing a lot of educating as we push forth this legislation. So again, thank you for your time today. Thank you for listening to what I had to say. And thank you to all of you for the wonderful work you're doing.
Thank you, Rep. Morrison. That was a really powerful story that you shared about that teachable moment. And I think you're right that what is most needed is teachable moments. And so we have a question in the chat that gets at that. You know, there are folks who are in our audience today who want to stay close to the legislative work that you and Rep. Campos are doing. So what's next? How can our audience members support your good efforts at the state levels in Delaware and Oregon?
I'll jump in first. I mean, the first thing, I guess, is to educate people one-on-one. It really does spread out. You know, with our groups that we're working with, we are working to put together a big network of groups in Delaware. And they're going to work on things like postcards, lobbying legislators, calling legislators. When we have our committee hearings, they're open to the public and people can make public comment for 2 minutes. Emails, all kinds of things to contact legislators. In Delaware, a lot of legislators really listen to their constituents. Our districts are very small. We only have about 25,000 people in each district. So, you know, people are swayed if they get a lot of emails or something on an issue. So I would encourage anybody to get involved with these local grassroots organizations to see what they can do from there.
Wonderful. And Rep. Campos, the same question, how can people support the Right to Rest Act moving forward? In case she had to step away, Rep. Campos was traveling today. So in case she had to step away, another question still going to support. Obviously, it's best to hear from constituents, but there are stakeholders who want to see your states be models for other states to follow in suit. And if they wish to support, is there a hashtag that can be used on Twitter or a messaging campaign, a letter that they can sign on to? And is there a website that people can visit to stay up to date on those types of efforts?
For us so far, those are good things. There is not. But what I will do is I will drop my email in the chat, and anybody who would want to help or get in touch with me, feel free. That would be wonderful.
That is great. And just another reminder for folks, I've seen a lot of questions about whether or not, thank you. So Rep. Morrison's contact info is in the chat. There have been a lot of questions in the chat about whether or not this will be recorded. It is being recorded. You can access the slides as well as the recording on our website. You also can stay up to date on what's happening with Rep. Morrison's bill as well as Rep. Campos's bill. And other constructive policies around the country by following us on Twitter at HNH campaign. Please consider endorsing our Housing Not Handcuffs campaign. We have a website, housingnothandcuffs.org, all one word, housingnothandcuffs.org. And there you'll find the statement where you can endorse the principle that housing is the solution to homelessness and that people need housing and not handcuffs. And we'll put all of that information in the chat as well. I'd like to transition to ask a couple of other questions. First, Rajan, can you talk about why, when we have such a robust, and you hit on this a bit in your presentation, but we have such a robust kind of lengthy history of looking at city policies that are often the subject of enforcement. What is the benefit of looking at these same types of policies at the state level?
Sure. Thanks for that question, Tristia. So I would say a couple things. First of all, when you're trying, depending on the legislation, when you're trying to fight against a local policy, it's important to acknowledge or recognize what is present at the state level with respect to that policy, because that can dictate or restrain what actions you can take at the local level. Joe spoke so strongly about the Texas legislation and the parts of that legislation that, despite, I guess, potentially not necessarily needing to be there, but very explicitly restricting and prohibiting local level advocates and local level communities from engaging in engaging in responses to addressing homelessness in their own communities that go against what the state level statute says. So just by itself, knowing that the state level statute is there informs and impacts local level advocacy. So if you're trying to remove those statutes, you have to know it's at the state level. Additionally, I would say that it's not just important to know at the state level for the sake of informing local advocacy, but it's also helps inform people's positions on the subject. And what I mean by that is that when you're aware of, like, just honestly how ridiculous it is that some of these statutes are, or some of these behaviors are prohibited at the state level, like in Wisconsin, like there's being statutes prohibiting essentially being able-bodied and not working, and actually prohibiting that. Just the fact that that's at the state level should make people mad. It made me mad looking into some of these statutes when writing the report. It makes Tristia and Eric mad every single day. And it really should make people mad. And that helps galvanize and energize all sorts of advocacy at all forms of level, when you're not just trying to take away something bad, but also replace it with something good. So I think that it's important to just have this information, to know what's there for all forms of grassroots advocacy and all forms of just creating something good that actually helps people. You got to know what you're up against.
Thank you. And agreed. There is a question in the chat, and I don't know if Rep. Campos has returned to the screen, but if she has not, then I'd like to answer this question. It comes from Tim McCormick about alternatives, meaning an alternative, as he describes it, to the right to rest law that was a bill that you heard Rep. Campos describe, and why another policy, HB 3115, which did pass in Oregon, is that an adequate response? Just for the audience's information, 3115, which is now law in Oregon, was an attempt to codify, although in my view, it didn't do that in an adequate way, the holding of the Martin v. City of Boise case, which was a lawsuit brought by the Law Center, Latham and Watkins, and local counsel at Idaho Legal Aid. That stands for the proposition that it is cruel and unusual punishment to punish a person for engaging in universal and unavoidable resting activities in public space when they lack an indoor alternative. What 3115 did in its attempt to codify that holding, which arguably could be a good thing, is take a step, I think, in the wrong direction. What it codified was the ability for local governments to instill time, place, and manner restrictions on resting. And the effect of that, we've already seen. For example, one of the very first locations in the state of Oregon to enact a time, place, manner restriction was Medford, Oregon, where they made it unlawful to use a tent as a manner of resting. Human beings don't just need to rest, they need to control the ambient temperature in order to rest and in order to survive. We don't have natural protection from the elements like fur and other protective things that other species have evolved to have. We really need indoor shelter. We've evolved to live indoors, and that's what everyone deserves. But it's prohibited under what is considered a time, place, manner restriction that is expressly permitted under 3115, which I think undermines not just constitutional challenges to those types of restrictions, but is falsely seen as a step in the right direction when in fact it just keeps us in the same place where we don't want to be, which is where people are living outside and facing punishment for that unfortunate reality that they cannot change. And Rep. Campos, thank you so much for returning. I don't know if you want to have a final word on the matter and say why the Right to Rest Act, which takes a different approach, is the approach that you favor.
Well, I'll just add, because I think you did a great job in that, to say that 31, solves or looks to really address these things, when it doesn't, is actually pretty harmful. One of the things that we see in the legislature is that when we tackle issues and it looks like we've done something, people come back when you try to address the issue in another way or continue to do so. People come back and say, oh, didn't we just do this? Or we just worked on this. Let's see how this pans out, and wait a while. And so it delays actually taking action the way in which the Right to Rest Act does, in really looking at the root of the problem and the way in which we are continuing to perpetuate houselessness. So that's what I'll add there, is that this narrative does end up creating a harm, that it is beneficial, that legislation is beneficial when it isn't.
Thank you so much. And with that, I want to thank all of our excellent speakers today. Thank you, Rajan, for drafting a supplement to our report. Please check out the report, the Housing Not Handcuffs 2021 State Supplement, available on our website. Check out the underlying report, Housing Not Handcuffs 2019. Please do follow us on Twitter, endorse our Housing Not Handcuffs campaign, stay involved, and let's all be part of the solution and the progress that we all want to see. Thank you so much to our audience for joining us today, and we wish everyone a fabulous day.